last name, and also just keep looking at me because that gives us the correct camera
Okay,
angle.
all right.
And then the years that you were an attorney that helped with the Atlanta student movement.
Is that the question?
Yes, sir.
Oh, I'm supposed to answer it on camera now?
Yes, sir.
Well, are we on camera?
Yes, sir.
My name is Howard Moore, Jr., and I was active as an attorney from 1962 until I relocated to California in 1971.
When we talk about the legal aspects of the Atlanta student movement, there were historic, nation-changing cases that came out of your office. Which ones were you involved in?
I was involved in a number of cases. I can't remember all of the cases in which I was involved. The most significant case in which I was involved that dealt with the sit-in movement was State of Georgia v. Rachel, which went to the United States Supreme Court. That was a very important case because it resurrected the 1866 Civil Rights Act, which allowed criminal defendants to remove their cases to federal court if they could allege and prove that they would be denied the equal protection of the law in the state court. And so we removed a host of those cases to the federal court here in Atlanta. And eventually that went through the Fifth Circuit. The Fifth Circuit agreed with us, that's the Fifth Circuit Court of Appeals, and then to the United States Supreme Court. That was perhaps one of the most significant cases. The next case I would rank in level of significance would be Bond v. Floyd, James Sloppy Floyd. That was the case that dealt with the exclusion of Julian Bond from the Georgia State Legislature because he endorsed the Student Nonviolent Coordinating Committee's statement opposing the war in Vietnam on the ground that it was an illegal war and that it promised to give to the Vietnamese and others a democracy which we did not know here in the United States. The next case that I would think would be of the most significance would be Carmichael v. Allen, Stokely Carmichael, later known as Kwame Ture, in which he was falsely accused of starting an insurrection in Summerhill in the fall of 1966 when an African American had been shot and wounded, and he had been asked, that is, Stokely Carmichael and the Student Nonviolent Coordinating Committee had been asked to come out and calm the unrest. Stokely was charged with insurrection, which was a capital offense, as well as charged with disturbing the peace, which is a local commonplace offense. The insurrection statute had been declared unconstitutional by the U.S. Supreme Court over 20 years earlier. Nevertheless, the state of Georgia resurrected that statute to prosecute Stokely Carmichael. The case resulted in a decision of nationwide importance that many people used across the country because it was the first case in the history of the United States in which a local disturbing the peace statute or ordinance had been declared unconstitutional due to its overbreadth and a lack of specification.
Okay, now when we talk about the cases, you can't talk about them without talking about the people. And you had a law firm where I've had just person after person after person just remember you as stately, eloquent, powerful, gentleman who not only knew the law, but could shame a judge into rendering decisions. That's almost a godlike status. Did you feel that way when you were in the midst of all these things?
No, I did not. I only felt that I was a technician and that I had been given a skill and a training and that I should put my training and skill to the use of the people. And we were so busy working that most people I don't remember because it wasn't a matter of having a case. You have one case, you may have 100 cases. Or you may have a case in Atlanta in the morning and another case in Madison, Georgia in the afternoon, or another case in Savannah, or Brunswick, or even someplace out of state. So we were on the move all the time. Because there was a dearth of lawyers. When I began practicing in Atlanta in 1962, that I was the 10th lawyer, close to the 10th lawyer in the entire state, African American. And at that time, I think the African American population of Georgia was approximately a fourth or 1/3 of the population of the state. But there were only 10 African American lawyers, and of those 10, only 3 or 4 in the entire state handled civil rights cases. So the work was really staggering.
Now, we talk about the staggering amount of work, but I also want to ask you about the people in your law firm. Go through the people that you worked with and tell me what stands out most in your memory and your heart about working with them.
Well, that's a big question. In my law firm, when I initially returned to Atlanta, I worked with Donald L. Hollowell, who had established himself in Atlanta in 1952 and had won some remarkable cases. Perhaps the most remarkable case of all that's not very well known is the case of Clarence Nash. Nash was accused of murder and rape. And Hollowell, who was just out of law school and had been admitted to practice for 2 years, was hired to defend Nash. First of all, Hollowell was able to get his confession thrown out because it was a product of coercion. In the retrial of the case, I don't want to go through all the details of the case, he was able to do something that was of epic and historic proportions in a sense. The principal eyewitness against Mr. Nash was certain of Nash's identity because he claimed that he'd seen his face and his appearance clearly in the light of the moon. But there was just one issue with that person's story. On that particular night, there was no moon. And Hollowell there was a moon, but the moon was not visible. Hollowell produced documentation from the Naval Observatory showing that it was overcast that night, and also from the Farmer's Almanac. And Nash was acquitted. But underneath that was something else that was really dangerous for Hollowell and demonstrated his courage. Because at that time, when an African American, or a Negro as we were known then, was accused of raping a white woman, the woman victim would be brought into court and she would be asked about the rape, and it would be a single question usually. Did he put his private parts in your private parts? And the standard response was for the woman to lower her head and look down and answer softly in a demure voice, yes. After she would answer yes, there would be no further questions on that issue, even though the defendant's life depended upon it, okay? In this particular case, Hollowell didn't accede to that standard of practice and questioned the victim extensively about her story that she had been raped and discredited her. And that, of course, contributed to the acquittal also. But that was really earth-shaking and established Hollowell as a courageous lawyer.
You lose your train of thought? That's fine.
No, it's not my train of thought. It's my feelings.
Well, share them with us.
I don't want to share them with you because they're too strong.
You guys had more than a law firm.
Well, I haven't finished speaking about the other people, too.
Okay.
There was Horace Ward, who later became a judge. As you know, Horace Ward, after he graduated from Morehouse College, applied to the University of Georgia to be admitted to his